Hello friends, in the series on the income tax cases, today we will discuss the case of Krones versus Deputy Commissioner of Income Tax. This case has been reported in 108 ITAT Tribunal at page number 705 and the matter has been decided by Delhi ITAT D bench and the date of the judgment is 30th December 2022. In this case, the issue involved is that whether an agent is a dependent agent of the assessee or not. What factors should be considered before declaring an agent to be dependent agent permanent establishment. In the present case, the facts of the case are like this, that the assessee is a German company who is specializing in beverage filling and packing technology. K is a company who is wholly owned subsidiary of Assessee and K is sole selling agent and marketing agent of the Assessee and selling the products of the Assessee. During the assessment proceedings, the learned assessing officer on the basis of K's transfer pricing report treated K as dependent agent permanent establishment. The assessee has and the K has the apprehension about this, that the K should not be treated as dependent agent permanent establishment. When this matter came before Delhi ITAT, the ITAT observed that the revenue of K from the commission earned from the assessee was only 11.5% and the remaining 89% was from its own sources. So, in these circumstances, when only the 11.5% income is from the assessee, it cannot be said that K is dependent agent permanent establishment of assessee. Apart from that, ITAT also observed that K was not economically dependent on the assessee. Assessee was maintaining its own inventory. The entrepreneurial skill was with the assessee and each party, that is the assessee and K, performed non-integrated business activities. The tribunal also observed that during the last 4 years, when the same matter was before the revenue did not pointed out anything which is contrary to the version adopted by the assessee, and in the last 4 years also K was not treated as dependent agent permanent establishment. And it was also the point of the ITAT that on the basis of the case transfer pricing report, K cannot be treated as a dependent agent permanent establishment until and unless the other conditions for treating K as a dependent agent of the assessee are fulfilled. In this case, tribunal ultimately said that K is not dependent agent. Apart from that, there was one more issue in this case. The interest under section 234B was levied on the assessee. It was the submission of the assessee that my TDS is to be deducted, but the payer didn't deducted the TDS, so I am not liable for section 234B interest. The law point on this case is that when the payer defaulted in not deducting the TDS, the payee cannot be penalized for paying the interest under section 234B because when the assessee calculates its tax liability or the interest liability, then the assessee considers the TDS which is to be deducted, and if this TDS is not deducted by the payer, the assessee should not be penalized. The ITAT also gave the reason for that and said that if the payer has not made the payment of the TDS on time, then the department has every right to collect the interest from the payer, so the payee should not be enforced to pay the interest under section 234B. At the end of this video, once again I am repeating the name of the case. The name of the case is Krones versus Deputy Commissioner of Income Tax, and this case has been reported in 108 ITR at page number 705, and the matter has been decided by Delhi ITAT D bench, and the date of the judgment is 30th December 2022. Thank you, friends.